Good morning to everybody, and thank you for joining us for the second in our series of creating a sustainable family business. Today, we're going to be looking at decision making and the structures that support that. Now, I'm Silvia Vitiello. I'm a partner and I head up the family business team at Moore Kingston Smith. And as I say, we have quite a packed agenda to look at this morning. So I'm going to first of all introduce the panelists who are here with me today. They've been drawn from both our tax and legal teams, so they've got lots to say about decision making and structures around that. And we all work together, so we probably will be chipping in with anecdotes and bits and pieces that we have on areas that we're talking about. But the first person I'm going to introduce is Yvette Jacobs-Lee. She's our family business tax partner, and she works with many family business clients, advising on tax effective solutions where the business and the personal tax issues collide. We have Guy Sterling. Now, Guy is also a partner in our tax team, but he focuses on personal tax of the individuals behind each business, reviewing their income and advising on tax mitigation strategies. And last but not least is Alison Morris. Alison is a partner in our legal team. Now, she heads up the private client legal team and works closely with the family business tax partners, as you can imagine, to ensure that the family business is protected for future generations and that there's a smooth handover. She specialises in wills, powers of attorney, probate and trusts. Now, for decision making and structure, the two go hand in hand, and it's really important to make sure that you have the right strategies in place to allow you to make effective decisions for your business and for your family, of course, and that becomes more straightforward and ultimately more effective. Now, I'm going to talk about the structure and some of the simple business ways that you can look at how you make sure you're making the right decisions a little later on. But I'm going to start the session by launching into an area that is at the core of family businesses and therefore can be something of a minefield. No, it doesn't have to be, but it can often be. And that's the actual ownership of the business and the potential for those intergenerational tensions, shall we say. So, for example, around the whole area, the most important thing to start with is the process for decisions and how that's going to be supported by share ownership and the ownership of the business. Now, it's quite a complicated area, so I think both Yvette and Guy are going to run through some of their areas where they often see problems and misunderstandings arising in the work. And the I was going to say tricks, but they're not strategies. They're strategies for dealing, not tricks at all, strategies that they have that they use typically with businesses. So I'm going to start with handing over to Yvette. And can you talk to us about share ownership and some of those solutions that you've used in the past to find the answers that are needed?
Absolutely. Thanks, Sylvia. Well, we know very well that share ownership can be an emotive issue. And in the last webinar, you might remember we spoke about the direct gifting of shares. And that, of course, is still something that would be part of discussions that we have with our family business clients. But there are alternatives which provide nuances to the passing on of shares. And one of those is giving share options. And that's something that we're seeing becoming far more important in the planning for the family companies that we work with. So options are often mentioned in planning. And to be clear, the options are a formal opportunity to acquire shares in a company at a point in the future. And those options might be over shares that are already held by another shareholder, or they might be shares that are going to be newly issued by the company to the option holder. So there's two basic types of share options. There's approved share options, which means that they're in one of the approved schemes that are set out in legislation, so tax advantaged. And there's also unapproved options. Probably the best type of approved option we use with our family business clients are EMI share options, which stands for Enterprise Management Incentives. But also unapproved options are very popular. And although they don't have some of the same tax advantages, they can be a way to set out parameters for future share ownership, which can be really important in that decision making for family business and passing on who's going to be sitting at the helm in the future. Guy, you do a lot with trusts in this area, don't you?
I do. Thank you, Yvette. Yes. And trusts have a reputation as being used for various tax arrangements, but a better way to view them is as a practical way in which assets and in particular shares can be passed down to generations in a safe wrapper. Younger generations can be given an interest in a business without the direct control over the company, and the challenging issues that can arise when introducing parties not ready for involvement in the business. The two most common types of trust that lifetime trusts that I find clients use are discretionary and interest in possession trusts, which are also known as IIP trust. In a discretionary trust, the trustees have control over the distribution of income as well as capital, and that's controlled by the terms of the trust deed. In an IIP trust, the beneficiaries are entitled to receive the income as it arises within the trust, while right to the capital depends on the terms of the trust deed. The tax differences are also important, but we'll return to talk about those in more detail later. Trusts are typically used where younger children are involved as well, but they can also be used for different groups or classes of beneficiaries, allowing decisions to be made at a later date on appointment of the shares absolutely. So passing back to you, I think, Silvia.
Yes, I'm on mute. Sorry about
Right.
that. Thank you, Guy. That was one of the things I said I wouldn't do. So thank you, Guy. Well, so far we've looked at share ownership and the different ways that you can approach transfers of shares, dealing with those intergenerational movements that you need. But we've talked about that really where you're doing it during someone's lifetime. There's lots of reasons why you would want to do that so that you can have some stewardship as it passes across. But of course, that doesn't always happen. And that's often where, Alison, you sort of get involved in these sorts of things. And your work around wills and arrangements that are made for after death is something that's really important and we often see happening for our clients. Can you run through some of the typical arrangements that you put in place to help your clients with that sort of transfer of shares?
Yes, thanks, Sylvia. Yeah, well, my experience with family business owners is that they are incredibly busy people, working hard every hour of the day to try and create a very successful business which they want to pass down to their family. And when they're not working hard, they are spending whatever precious free time they may have with their children, with the rest of the family. What they tend not to think about is what would happen if they weren't around to run that business. And it's incredible, really, to me, the number of business owners I meet who have not got a will in place. Not just business owners, actually, other people as well. So if you don't have a will in place, then the business could collapse in circumstances like that. And the main problem with that is that if there's no will in place, then your business, your share of the business, will be distributed in accordance with what we call the intestacy rules. And the intestacy rules set out how your estate is distributed. So if you've got a spouse and you've got children, then the first £322,000 will go to the spouse, and the rest of your estate, that will include the business, will be divided as a half share for the spouse and a half share down to the children. And of course, if you don't have a spouse or any children, it go back to your parents, which also might not be what you would want to happen. So the first thing I say to business owners is, have you got a will in place? And if you haven't, why not? And let's do that. The trouble with that is that most business owners look at me and say, well, you know, we don't know. We don't know what to do. They don't know if the children are going to be old enough to manage the business. They don't know if the spouse is going to still be alive when they die, whether the spouse would want to run the business. Quite often the spouse isn't interested sometimes. They don't know if the children are going to become involved in unsuitable relationships, whether they're going to be financially mature enough to deal with the business, even if they want to run the business, because again, you have these ideas, don't you, that the family business is going to pass to the child that's showing the most interest at the time. And then suddenly, 10 years down the line, the child's not interested at all in running the business. So it's what certainty is there going to be. And because they're not sure what's going to happen, most people take fright and say, well, I'm not going to do anything at all then, and I will try and carry on living and not think about that. And that, of course, is the wrong way to go. So they know what they don't know what's going to happen, but they do know what they would like to happen. So if I say to a business owner, well, what would you like to happen, now? If it's suddenly to happen now, what would you wish to happen? And at that stage, they can say, yes, I do know what I'd like to happen. I'd like the business to carry on. I'd like my spouse to be provided for, maintain the same standard of living that they would have become accustomed to, during our happy marriage together. I would want the business to keep going. I would want that to be as tax efficient as possible. I've been to my accountants. I'm not entirely sure that my business is going to benefit from business property relief. But obviously, if it is going to get that, then I would want that to take full advantage of that. And I would want the whole of my estate to be distributed, in accordance with these wishes. Now, when you've got family business owners who are so uncertain, but sort of have an idea of the way they would like things to go, then
I think we've lost Alison a little.
Oh, have I lost me? Am I back again?
Have we got you back, Alison? We lost you for a moment.
Oh, okay. I phased out. You tried to switch me off, Sylvia.
I didn't. I promise.
Yeah. So when we have family business owners who aren't sure, but have a rough idea what they would like to happen at that moment in time, we say to them, well, why don't you do a very sort of flexible will? Appoint executors and trustees, or executors who are going to administer the estate and manage the business. Sensible people who would have some sort of business acumen. So why don't you bring in, people in the business who would be able to manage the business? Bring in your accountants, bring in your solicitors, bring in professionals, bring in family members, appoint executors, and then say that the beneficiaries, and I'm going back to what Guy said here, discretionary trust, say that who the potential beneficiaries of your estate are going to be. So you would say the potential beneficiaries of my estate are going to be, my spouse, my children, my grandchildren, my nieces, my nephews, my godchildren, all the other family members, extended, stepchildren, etc., 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 as wide a class of beneficiaries as you would wish to be considered as potential beneficiaries of your estate, and also give your trustees, your executors who will become the trustees of this discretionary trust, the ability to add beneficiaries after your death. That's quite important, because as you go along in life, you're never very sure. Other people might pop up and show an interest in the business. So if your trustees can add additional beneficiaries, that would be good as well. And then you sign your will, and that is the will. It's a nice, flexible will. Now, the trustees, then when the time comes, they are guided by what we call your letter of wishes. So you write a comprehensive letter of wishes by you guide your trustees and how they're going to distribute your estate. So you say, at this moment in time, my business comprises of this, my assets are the house, the business, I've got so much in the bank, I've got this, I've got that, I've got 3 young children, I've got a stepson who is, very interested in running the business. I've given some shares to this child. I haven't given any shares to that child. I would eventually like you to treat them equally. So I want you to be absolutely certain that on my death, even though some of the children have had some shares during my lifetime, that other children, there's some sort of leveling up, shall we say? That's a key word, isn't it? Leveling up, we like that. And you you write your letter of wishes based on the circumstances at the time. Now, 5 years down the line, your circumstances have changed. The whole family circumstances have changed. You rewrite your letter of wishes. So it's a really nice, flexible arrangement. The great thing about a will like that is that once the will's in place, you don't need to change it. So clients like the fact that they just pay for the will once. They love that. And then when I say to them, well, your letter of wishes, you can do that yourself. They like that even better, because they can then update their letter of wishes when the circumstances change. And nothing happens, because we say that a will is ambulatory. A will walks with you through life. Nothing happens until you die, and then at that point the will kicks in, and hopefully your trustees will know what your wishes are. It doesn't have to be a written letter of wishes. Everybody talks about a written letter of wishes, but actually, if you're keeping everybody updated, you're telling everybody what you want. Wishes are wishes, aren't they? A letter of wishes is not legally binding. But when you die, then the idea is that your trustees, your professional advisors will all sit down round the table. They'll look at everything. They'll say, right, what are the family circumstances? Who needs what? Who's in a bad way? Who do we need to protect? Who's going through a divorce? Which child has gone off the rails? Which child has married Mr. Wrong or Miss Wrong, etc., etc. Because we want to keep it in the family, don't we? What's the tax situation? Let's have a look at the tax. Are we going to get business property relief? Let's pull in all our accountants, etc. What are the financial circumstances for the family? And then you divide the estate up, given what you know at the time. So that's, sorry, I've gone on a little bit, I think, Sylvia, but
no, that's great, because it's a huge
sort of,
subject, isn't it?
It's a massive subject,
and I think,
and that's
I
sort
think
of
you're right. People are frightened to talk about it. It's
They
almost
are.
as if you make a will, I'm going to die, whereas of course
Yes,
that's not
but
true.
exactly. But the two certainties we have, are our death and taxes thing, aren't we? We all know it's going to
Yes.
happen. There's no point shying away from it. It is
Mm.
going to happen. We just don't know when. So that's one way of doing it. If people don't like that idea, then we can still put a sort of what we call a hotspot provision in a will to make quite sure there's some sort of equality between the children, because most parents want their children to be treated equally, whether or not they're interested in the business. So we can put that in place. Or we could just carve out the business and put that into just discretionary trust, the business only, and leave everything over to spouse and down to the children. So you've separated it out. There's so many options available. It's just a question of me sitting down and chatting it through with you all.
Oh, it's fantastic, Alison. It's great to hear you talk about it. So not wanting to be the prophet of doom, I'm leaving that to you. You've spoken about death, but what about the loss of mental capacity? What do you think we should think about there?
Yeah, yes. And again, we don't like to think of that, do we? And we tend to think lack of mental capacity. We think elderly people, we think Alzheimer's, dementia. We think that's not going to happen to us. But sadly, it does happen, doesn't it? The cycling accident as you're going to work to run the family business. The head injury. So yes, again, my advice to business owners is that you should definitely put in place a lasting power of attorney. There are two sorts. There's a property and financial affairs lasting power of attorney, and there's a health and welfare lasting power of attorney. I'm not going to talk about health and welfare ones, because once I start talking about lasting powers of attorney, as you know, Yvette, I could talk for hours. So I'm going to try and summarize this as much as I possibly can. A lasting power of attorney is a legal document whereby you appoint somebody you trust implicitly to deal with your property and financial affairs if you are unable to do so yourself. And people tend to think mental incapacity, but actually physical incapacity, have the stroke, not be able to sign things, an LPA would still come into its own, but the attorney would just be acting on your instructions there. The trouble also, if you were to lose mental capacity without a lasting power of attorney in place, is that banking law kicks in. and it says if you lose mental capacity, then the bank account is immediately frozen. So the family business bank account could be frozen. Overdraft facilities would also be frozen. So if your family business cannot receive money, people can't pay into the bank account, and similarly, you can't pay out of that bank account, then the business is at risk. Worst case scenario, you're heading down to liquidation, bankruptcy, if nobody can operate and nobody can pay the bills or pay the wages, etc. If there's no lasting power of attorney in place and somebody needs to deal with the business because you've lost mental capacity, then there'll be an application made to the Court of Protection, and that can take up to 6 months or so, possibly more. So you have to say, would my business survive if nobody could access the bank accounts for 6 months or so? I doubt it. We recommend that business owners put in place two lasting powers of attorney. We say, a personal one for your personal finances, for the, so that, possibly, again, I'm thinking appoint spouse and children as your attorneys so they can deal with your personal finances, and then put a separate business, property and financial affairs, LPA in place, whereby you would appoint people who have got business acumen and people who know the business. So that's not necessarily going to be the spouse who might not be interested in the business. It might not even be the children who might not be interested in the business. It could be the nieces and nephews, stepchildren, etc. But for the business LPA, you would be appointing people who understand the business and who will be able to carry on operating the business. And also a business LPA is useful because even if you haven't lost mental capacity, once it's registered, it acts like an ordinary power of attorney. So it could be useful, say if you're going on holiday, going abroad, going on your 3-month cruise, and some contracts have to be signed suddenly, something like that. And, I know you can use DocuSign, but, my experience of, well, I've only been on a cruise once, and there was no internet unless I paid like £300 extra for the internet. So, quite a few people when they're off on their holidays don't have internet access. So it's not always easy to do DocuSigns. It's really, really useful to have an attorney who's sitting there who can, if necessary, start signing, any paperwork you would need to sign as a business owner whilst you're away. And of course, that could just be whilst, you could be taken into hospital for an operation or something like that. There could be all sorts of reasons why you might need an attorney. Lasting powers of attorney, I always say to clients, see them as an insurance policy, put them in place. Hope to God they're never used. Hope you never lose mental capacity. Hope that, you will, we all want to do the same, don't you? We all want to. You're allowing me to talk too much, I think, of it. But I was going to say, what we all want to say. I've been dealing with this for so many years, and all my clients, they want the same. And as one client classically said to me, she said, "What I'd like to do, Alison," she said, "is I'd like to go to bed one night and wake up dead." And I thought, yeah, that's exactly what we all want, isn't it?
I think you have very special conversations with your clients.
Well, it's a great, I mean, it's a great honor for me as a solicitor, we're a bit like the priest in the confessional box. And I'm sure you, Sylvia, Yvette, Guy, you're the same. It's amazing.
I think
amazing what we hear, but of course we can't advise properly unless we hear all this. So we do hear about all the problems and all your concerns and all your worries, and that's our job, is to try and make quite sure that everything is set up correctly. So if the unfortunate were to happen, we have everything in place, so there is a smooth handover.
And I think some of the things that you've talked about are really flexible and they work well. And I think often clients are very much put off by the thought of a will being a very complicated and huge document that's got to be
Yes, yeah.
and
it
I
doesn't
think what
have
you
to be.
no, it doesn't.
No,
It can be
no.
simple, and the letter of wishes can be a very malleable sort of document.
Yes.
It can say what that person wants. I think the trick to it is to ask the right questions, which you were talking about at the beginning. So thinking about something as huge as what happens when you're not here is difficult, whereas you sort of frame it slightly differently. And if our clients start to think about, well, what would I really like to happen? You can start to draw out those threads and put in some of those practical decisions, really, and give people those options. So I think what we've done at the moment is to talk about a number of approaches from practical perspectives and hopefully demystifying some of those things when people talk about LPAs and stuff like that. You know, you perhaps don't know what they are, but I think they are very practical documents. And so we're looking at that share ownership and the transfers and the transitions, which are all very important. But I think what I'd like to do is to just jump back to Yvette and to Guy to talk a little bit about tax. As we said, death and taxes are always certain. And just to do a little bit of demystifying on some of those taxes that may come in when you're doing share transfers, because I know that is something that my clients will always ask about, because it can be an important aspect, an important feature of that. So I'm going to go to Guy first of all, because you talked about trusts. Can you tell us a little bit about the typical sorts of taxes, some of the things that you're going to come across when you start thinking about using trusts in your family business?
Thank you, Sylvia. Yes, so there's lots of taxes, unfortunately, to think about with trusts. The first issue is a transfer of shares to a trust is a disposal for capital gains tax purposes. And that would normally create a tax charge on the individual, the settlor, who's transferred the assets to the trust. Thankfully, holdover relief can be made where the transfer is chargeable to inheritance tax, and so we'll come into the inheritance tax issue shortly. And so that enables the trustees to take on the base cost of the shares for capital gains tax purposes, which commonly we find is quite low with our clients. I would expect a transfer of shares in a trading company to qualify for business property relief, although this is not always the case depending on what other assets are held within the business. So even though that would prevent any IHT being payable, but even so, a holdover claim can still be made in those circumstances. Holdover relief, though, is not available if assets are transferred to a settlor interested trust, and that's one which includes the following individuals as beneficiaries: the settlor, their spouse or civil partner, and their minor child or their minor child. It does not include, though, adult children or minor grandchildren. So there are good opportunities, including those within the trust deed. In some circumstances, we find clients are comfortable in paying the capital gains tax on the transfer to the trust on the basis they would qualify for business asset disposal relief, or BADR. And that gives a lifetime allowance of £1 million of gains that are taxable at 10% instead of the normal higher capital gains tax rate of 20%. In this situation, the trust takes on the market value of the shares at the time of the transfer. BADR is a very valuable relief, though not as valuable as it used to be, but it's also available to trustees, but in precise circumstances. And at a headline level, this is where the beneficiary of the trust has an interest in possession in the trust assets, and the individual satisfies the qualifying conditions for BADR. Typically, that's the beneficiary will need to be an officer or employee of the company for at least 2 years before the shares are sold, and also have held the interest in possession throughout the 2-year period. Turning now to the income tax on trust. The treatment is very different depending on the type of trust, whether it is an IIP or discretionary trust, the ones we mentioned earlier. A discretionary trust is taxable at 39.35% on the dividend income receives and 45% on other types of income. However, when an income distribution is made to a beneficiary, this is made net of a 45% tax credit. And this can be very useful for clients, particularly with grandchildren who have not used up their personal allowance. So taking an example of the trustees want to make a £1,000 distribution to a beneficiary. They actually make a payment of £550, and that comes with a tax credit of £450. This distribution is taxable income of the beneficiary, and depending on their circumstances, may be able to recover all of the £450 tax credit by submitting a repayment claim to HMRC. And so we do find this quite often is helpful in school fees planning with some of our clients. As mentioned earlier, a beneficiary of an IIP has a right to the income of the trust as it arises. So this income is taxed at the basic rate of tax, which is 8.75% on dividends and 20% on other income sources. And this forms the taxable income of the beneficiary. So depending on their personal circumstances, this tax could be repayable or additional tax could be due. Transfers to a trust, so moving on to inheritance tax issues. So transfers to a trust are chargeable lifetime transfers. Normally, an individual is restricted to a limit of £325,000 before the transfer creates a lifetime inheritance tax charge at 20% on the excess of over £325,000. However, where the shares qualify for 100% business property relief, there is no immediate charge to IHT on the transfer into trust. It's important to think about future events from the outset. So it's not just the tax, but it's looking at the sale of the company, which could give real benefits as assets can be put into trust without an entry charge. However, there could be charges at 6% on each 10-year anniversary of the trust creation, and further charges when capital distributions are made. Again, it's a useful opportunity for the family to have discussions and thoughts as to the benefits of using a trust, irrespective of the drafting of any legal documentation. Yvette, I've talked about tax. What needs to be considered in respect of the shares that are transferred?
Yes, well, I touched on earlier about share options as an alternative to trusts, which might be useful in family companies in different types of circumstances. So thinking about the tax considerations for share options, I suppose, share options, they're always tax-free at the time the option's granted, but a tax charge may be expected when those options are exercised and the actual shares are required. And that's the point that corporation tax relief may be triggered as well when someone in the business acquires those shares. So we mentioned earlier the approved enterprise management incentive share options are something we commonly use with trading family companies that we work with. And with those type of options, the taxable value is actually based on the value of the shares at the time the option's granted. And that's one of their great advantages, because if someone's paying the price at the time the option was granted, they're paying it some years later, then any uplift since the time the option was granted can be not taxed at acquisition, which is a great boon for perhaps the person acquiring the shares, and a reason why we might want to grant options in advance to be exercised in the future. Although that might sound good, and I'm making it sound good maybe, EMI share options are not available to all types of businesses, all types of company. And that's when we might consider other planning tools to achieve a similar outcome for those businesses. So, for example, something we're doing a lot, increasingly, is growth shares. And that's when we create a special class of shares which are intended to give an interest in the future value of a company. Because the rights of those shares are attached to future growth, the current value of those shares are low or limited, and that means that the tax charges on acquisition are likely to be low because they correspond to those current value of the shares. Guy and I have talked quite a bit about tax, but of course vital to something like growth shares or any share acquisition really is the underlying valuation which drive those tax charges that become due. And I'm often involved in tax valuations for businesses, and depending upon the type of business that we're valuing, the shares that we're looking at, we would look at valuation on a number of bases. So we might look at the asset values of a company or the dividend yields, particularly for smaller investment holdings. For trading companies, we often look at the past profits as an indication of future performance. And all of those are different methods of valuation that we might consider. We may bring them all in a composite valuation, depending upon the type of business that we're looking at. For small shareholdings as well, we'd also consider a minority discount, which would reflect the level of influence and control of a shareholder with that small shareholding.
If I could just jump in there, I mean, valuations are not necessarily important or binding when the gain is going to be held over.
You're absolutely right, Guy. And if we can hold over a capital gain, then that's great. We'll defer the tax charge for later, absolutely. But we don't always hold over the gain. And certainly if we're looking at share options, income tax charges are there to consider as well, where we don't have the same options to defer. So valuation's a thorny one, but you're right, Guy. If we can defer that tax, why not?
Absolutely right. Thank you so much. Two of you have run through, and I know it's a very complicated and involved area, but you've given us some of the highlights of things that I think our clients can expect to be talking about with you, or perhaps on the receiving end of your calculations. A really important area. Now, so far, we've really talked about dealing with family members as shareholders, as the people who hold the shares, the control in the family. And of course, it is likely that some members may also be significantly involved in the actual operation, the business of the day-to-day of the company, the business of the family. And sometimes there may be extended family members who are involved in that too, or may not be. So there can be a whole mix of relationships in that. I'd like to take, though, quickly a look at two fundamental documents that I think every business, every business, but certainly every family business should have in place, because this mixing up between shareholding and actual operation in the business can often lead to some misguided understanding or expectations by family members. So let's have a little look at what we do. Now, as a business advisor, I always keep things simple because I think that life is complicated enough anyway. So I just have two documents that I really look at. So I look at shareholders and I speak to the shareholders in the family business, your investors. Your shareholdings have come to you from inheritance or gifts, or sometimes it's purchased or it's been transferred out, but you're holding the shares. And however you've come to hold them, you're the investor and you receive dividends as your return on investments. That's your part of the business. But for those that are involved in the day-to-day work, the operations or perhaps strategic direction, are going to either be office holders or employees. So office holders are directors of the business, or you may have people in senior positions in management for the business and how you run it. And as such, when you have duties as a director or as a senior manager or something, you will be looking after the day-to-day operations, formulating the plans, how you're going to make it profitable and sustainable. And you will receive your remuneration as that remuneration. You'll have your salaries and your bonuses and whatever schemes that come through. Those office holders hold important roles and they make very important decisions for the business. Now, this is a very simplified description because there can be all sorts of things in between. You will often have a class of individuals who hold shares and they're the investors. And sometimes those investors will include more remote members, perhaps of the family. As I've said, they've inherited parts of shares through death. Sorry, Alison, mentioning what you're talking about. They will have inherited them, but they'll have nothing to do really with the business. But sometimes there can be an unclear demarcation between the rights and the roles and the duties of that shareholder and the running of the business. And that's often where you can see relationships coming into play and having difficulties, because somebody who holds shares but with no knowledge of how the business is run or what the plans have been or how it's working, may feel that they do have some involvement in that, or some say in it, I should say, rather than involvement in it. And so it's really important to have a very clear document that shows who has rights in certain things and who has duties and responsibilities. And that just avoids strategy becoming confused. I'm being very nice about how I'm talking about it. I'm talking about arguments in the family, obviously. So firstly, you have the shareholders agreement, and that is exactly what it's talking about, a shareholders agreement. That's for the shareholders, that's for nobody else, that's the shareholders. And it's a really practical document. Now, certainly as a company, you're going to have a memorandum and articles of association. That's a very standard document, and it talks about the very basic structure of the company. But the shareholders agreement leads on from that. It sort of stands on that. And it talks about the business. It lays out the basic structure. Now, it's not like the Mem and Arts. It isn't constrained by any legality outside of the entity, but it is something that's got to work for that business and for those particular shareholders. And those shareholders will sit down together, or maybe on videos these days, and agree whilst they're all still friends. Is the important thing. They'll talk about what needs to be included in there and how it would be set out and what's fair and reasonable. So typically you'll see things about shareholders or share rights. So, you know, you may have different classes of shares. We'll agree how those share rights work. The management roles and responsibilities. So where does people get involved and what level of decision making should shareholders have some input? Conditions governing share transfers, I've got written here as a reminder, and restrictions on transfers, really important because you are a shareholder in there and there may be some preemption rights within your Mem and Arts, but this is very much more specific about who can hold shares. You can imagine that when shares are passed down, there might be marriages and divorces and whatever. You don't really want those shares being passed out of the family, or maybe you do. I don't know which side the family would agree with, but you want some restrictions to be able to give certainty to people who hold shares to know who they can and when they can transfer shares. Dividends and financing matters, that's always going to be in there. When do you get dividends? What size should they be? When should dividends not be paid? You know, there might be a big plan and all the money from the business is going somewhere else. Dividends can't be paid. And absolutely included in there is going to be dispute resolution, exit clauses, buyout provisions and valuations for Yvette. So it's really important that everybody sits down and understands. And there are other important elements of that, of course, too. You need to all agree with it. It needs, and I know we have a lawyer here who's going to say, it needs to be legally drafted. Absolutely. It's no point having some scribbles and notes that everybody makes and you all think that you agree. I think somebody, unfortunately, our late Queen may have encapsulated it lovely and say recollections may vary at a later date. So I'm going to bring that one in. Yvette's laughing at me. I think it's true. You think you've heard what everybody else has heard, so it's not until it's written down in a legal form. Secondly, I would say everybody has to sign it. It's all right having something that's drafted wonderfully. It has to be signed and dated. And the third one, which you will be surprised, I've had 2 occasions, I think, in my career where nobody can actually find it when it's needed. So if a lawyer does it, hopefully a lawyer at least will keep a copy of it. I'm being jokey about that, but actually it's really important. It needs to be drafted out. It needs to say what everybody's agreed. You all need to sign it, and then you need to know where the copies are of it. I think that's a really important base document, and hopefully everybody's got it. I would say you do need to go back every now and again and look at it because businesses change and things are a bit different now and people are different and you may have different expectations. Now, the second document, which is one of my favourite documents, I am quite sad. My favourite document is a family charter, and it's such a strong document. It's a very difficult document to do. But I do bring it into most discussions, either in its full context or in just little parts of it. And it's a great way about thinking about how you manage the matters, the operation of the business. Now, this involves both shareholders and also those involved in the business. And it sets out really what the expectations of anybody who's involved in that business, whether you're a shareholder or you're working in the business. And it sets out your basic tenets of the family, how you want that business to run, what your values are. And I'm not going to talk all the way through the charter. I think my colleagues are very pleased because they've heard me do it before, but I'm not going to talk all the way through it. But I wonder if we could just bring up a picture of it onto the screen. I have an assistant because my IT skills are not that good, but the family charter is there. I was going to say, I thought it was more than just a blue screen. So I've worked quite hard to make that look like a little house, but you can see at the very bottom, we have the structures and the values and vision. If you can actually articulate what you think your family business value is, what its vision is, it may be to honour the legacy of the family business that started 4 generations ago. It may be about sustainability or whatever, and how you want your basic structures to work. You will see then there's some slices above that, which actually go through ownership, leadership, employment, communication, and governance. And governance is about making decisions. All of it is really. Those are basic areas which, if you can sit down as a family and talk your way through what you think ownership should look like, where you think leadership should sit. If you're going to be employed in the business, what qualifications do you need? What skills do you need? I think by just running through all of those, you automatically cover off all the areas where there could be a miscommunication, misunderstanding by people very often who are sitting slightly to one side of the business, who are a little bit more remote, but have an expectation that maybe they're involved in all areas, or I can automatically become an employee of the business, but I don't have any qualifications. I don't know how it runs. Whereas if you can set that all out, it's in a clear charter. That's our charter. Now, again, that may change from time to time. You've got imbue, that's about you need to live what you agree in these things, and renew is to come back and accept that you have to renew it on a semi-regular basis, at least keep it up to date. Some of the important things are the two bottom ones, they're all important. Communication. So people who sit perhaps slightly to one side would like to know what's going on in the business. So maybe you agree that you're going to have perhaps an annual letter that goes out to say, here are the accounts, but let me explain what we're doing with the business. And governance has a very bad name. People think it's all about policies and procedures and note taking and minutes. And it is a little bit about that, but it is about making the right decision at the right time. So it is about being able to say this governance works for our business. We need somebody who, a very specialist business, we need somebody who's in a leadership role, and we need to hold regular meetings because we need to understand what's happening with the business, or we're investing, or we're doing whatever. So the family charter is the second document. I will concede that it is a really difficult document to start off from a blank page. But actually, I think some of the conversations where I've sat in and I've facilitated for family businesses, the conversations that they have had have been as important, if not more important, than the actual document that they end up with, because it takes people through a very simple route of saying, what do we want to think about ownership? Who should own the shares in this? Or, who should be employed here? What qualifications would really work for those individuals? And they're conversations that perhaps families don't necessarily have all the time. They can be things that people assume that they know. And that can be probably the most dangerous area when you're making decisions, because anything that comes as a surprise is rarely a very good surprise. Now, those two documents, I think, need to be put in place. The first one needs to be a legal document. The second one doesn't necessarily need to be a legal document. It's like a little bit of a strategic plan, but it does need to be relevant, and it does need to be available for people to see and to inquire about and to refer to, and be a workable document. I think you can take that, as much as I love that picture, you can take that picture back down again. So hopefully, I think in terms of where we've covered today, we've looked at some of those very basic areas around the shareholdings and the routes to actually ensuring that you've got the right people holding the right shares, or that you have, as Alison has said, taken looked at the sort of slightly dark side, but made sure that if something happens to you, it doesn't need to be compounded by shares and ownership and issues on top of the one that you'd be looking at. And then finally, the two practical things, I think, please do have a shareholders agreement. Do please agree it and put it in place whilst you're all happy and agreeing with one another, because when you're not agreeing with one another, you won't really have much of a hope. And this is something that you can fall back on, which will be a sensible document. And if you can make a start, and I've got some notes, and I'll refer to where we are on our web pages in a moment, as to how you can make a start on your family's business charter. It is a really very powerful document, and it can work really well. So I referred to governance, and that is about making the right decision at the right time. We've talked about lots of decision making and structures, and giving you the best chance of having a clear strategy to get things right for your business. It is trying to look at when things don't go particularly well, or are surprising, when you have those events. I'm not going to mention death, Alison, I'm going to leave that to you, but accidents and things and those sorts of stuff that happens. Now, it's been a very short webinar today, so we've really just touched on those points. And I think each of us could probably do more than an hour talking about our areas of specialism. And don't worry, we won't at the moment. But I hope that we've given you some idea of the basic ideas around ownership, how you can look after the future and ensure that it is what you wanted it to be. And then a couple of practical documents I think that you should have a look at. Now, there's loads more about all of these topics and more about family businesses. There's articles and insights, and there are short videos. Believe it or not, we can be short. And when we talk about what our pages. And on the family business page of Moore Kingston Smith. So just search for that. And if you do have any questions that we haven't really answered today, or you just wanted to hear a little bit more about something, then all of our contact details are on there. You can call us or phone us. we are real people. We're happy to pick up the phone and talk to people. Now, whilst I've been talking, I've been monitoring the questions that have been coming in, and I wanted to leave about 10 minutes, and I think I've managed to do it for just a few questions. We got quite a few right at the very beginning when we first started, so I'm going to amalgamate a couple of those. So I hope I answer your questions. If I don't answer the exact question that you asked, as I say, do call us back. So the first two that came up during the webinar straight away, and they almost came in at the same time, I'm going to combine those. And I think that's for you, Yvette. So I'm giving you a few seconds to get ready. The question that I think will cover the two of them is, so what do you do when you have some extended family members who don't really get involved with the business? They're small shareholders, and they sometimes cause some issues or problems running the business or for meetings or whatever. What would you be advising your clients where you have that kind of arrangement?
Well, I almost hesitate to say it, Silvia, when you've been talking about it for the last few minutes, but a family charter can be very useful in these situations. So sort of, I suppose, summarising what you've already said, maybe, the family charter pulls together what everybody hopes to achieve from the family business and their different expectations. So things we often see, like, do younger generations want the chance for work experience? Or do the non-working shareholders have certain aspirations in terms of dividends?